The case of Peter Chong and Anwar v. Khatija, BTMD Ibrahim, and Anwar 2018, 10 MLJ 735 serves as a significant authority in Malaysian jurisprudence because it clarifies the limits of applying English common law principles within the Malaysian torrent system. Section 6 of the Civil Law Act, 1956, prohibits the application of English law on tenure, conveyance, assurance, or succession to any immovable property in Malaysia. This case affirms that English law regarding land matters should not be applied as it contradicts with the torrent system in Malaysia, which requires registration of land title. Facts. On the 26th of February 1940, Argovind Dasami sold a piece of land in Bandar Georgetown, Penang, to Muhammad Ibrahim, who took possession of the land after the conveyance. Upon Ibrahim and his son Ismail's deaths, Ibrahim's daughters, Aisha and Khatija, took possession and were registered as joint tenants under the National Land Code Penang and Malacca Titles, Act 1963. Under joint tenancy, both owners share equal interest in the property, and upon the death of one tenant, the survivor inherits the property by right of survivorship. In February and September 1990, Aisha entered into 2 sale and purchase agreements with the plaintiffs, selling her portion of the land. Although the plaintiffs paid the full purchase price, Aisha passed away on the 4th of March 1998 without registering the transfer of her land interest at the land office. Following Aisha's death, her interest in the land was not transferred to the plaintiffs, as the rules of joint tenancy dictated that the interest passed to Khatija by right of survivorship. The plaintiffs sued Khatija for specific performance, arguing that Aisha's sale agreements had severed the joint tenancy, converting it into a tenancy in common, thus preventing Aisha's interest from passing to Khatija by survivorship. The issue was whether the English common law principle of severance of joint tenancy, particularly alienation, rei prefer jur I accrescendi, applied in Malaysia. The plaintiffs argued that Aisha had severed the joint tenancy by selling her interest in the land. They relied on the English principle from Williams v. Hensman, which illustrates that a joint tenancy can be severed by a unilateral act, such as entering into a contract of sale. Judgment Com. 7. The High Court of Penang rejected the argument that English common law principles of severance of joint tenancy applied under Malaysian land law. The court held that Aisha's unilateral act of entering into a sale and purchase agreement did not sever the joint tenancy, as she failed to follow the statutory process of partitioning and registering the land. Ratio decidendi. The court reasoned that Section 6 of the Civil Law Act, 1956, expressly prohibits the application of English law in matters related to tenure, conveyance, or succession of immovable property in Malaysia. Applying the English common law of severance would contravene this provision. Furthermore, the court ruled that English common law principles of severance are not incorporated into the National Land Code, which governs land matters in Peninsular Malaysia. Unlike English law, which allows severance through conduct or agreement, Malaysian law requires formal partition and registration of the dealings in alienated land under Section 205(1) of the National Land Code. Since Aisha did not partition nor register her interest, the right of survivorship prevailed, and Khatija remained the sole owner of the undivided land under joint tenancy. Stare decisis. The court referenced the principle from Kuhu, Leong Viku Chong Yok, where the Privy Council held that English law must be modified to suit local circumstances and prevent injustice. Applying this, the judge emphasized that the National Land Code prevails over unmodified English common law principles that do not align with Malaysia's land administration. The binding authority of United Malayan Banking Corp, BHD, UMSI v. Pamungad Hasiltana, Kota Tinggi, reinforced that the Malaysian land system is a complete code, precluding the importation of English land law unless specified by statute. In Peter Chong, the court rightly rejected the English doctrine of unilateral severance of joint tenancy as it conflicts with the Malaysian torrens system. As a matter of stare decisis, the court solidifies the certainty of the land register, affirming that joint tenancy can only be severed through statutory means, ensuring that the surviving joint tenants title remains indefeasible against unregistered claims. Overall judgment. In conclusion, the High Court dismissed the plaintiff's claim for specific performance, ruling that the English common law principle of severance of joint tenancy cannot override Malaysia's land statutes. Under Section 6 of the Civil Law Act 1956, English law on land severance is prohibited, and as a result, Khatijah remained the sole proprietor of the undivided land. The plaintiffs could not enforce the transfer of the land since Aisha failed to partition and register the land transfer before her death. This case also serves as a modern affirmation of the exclusivity of Malaysian land law and the statutory rejection of certain English land principles. It clarifies that legal practitioners cannot rely on English common law principles, such as unilateral severance, to alter the nature of land ownership in Malaysia. This case emphasizes that any land or property matters in Malaysia must be referred to the National Land Code, further limiting the English law from being imported into Malaysian land matters. Cass v. MPPL and ANOR 2022, 12 MLJ 135 Introduction. The case of Cass v. MPPL and ANOR 2022, 12 MLJ 135 illustrates the application of English common law via Section 3(1) of the Civil Law Act 1956. This provision allows the application of English common law and rules of equity as administered in England on specific cutoff dates, where there is a lacuna in Malaysian law. Due to the absence of a specific local legislation regarding the court's jurisdiction over the welfare of a child, the court applied Section 3(1) of the Civil Law Act 1956 to fill the legal gap where the local statute is silent. Fax, the first defendant, D1, a stewardess, and the second defendant, D2, a pilot, were married on the 3rd of March 2007. During their marriage, D1 gave birth to a daughter on the 23rd of June 2008. The plaintiff seeks a court order for a DNA paternity test, claiming that he, rather than D2, is the biological father of the child. He asserts that he had an intimate relationship with D1 from 2005 to 2014, both before and after their marriage. To support his claim, the plaintiff provided evidence, including photos and videos, showing him interacting with the child from 2008 to 2013, as well as financial records of regular maintenance payments to D1 until 2014. The main issue concerns the conception period, which is estimated to be between August and October 2007. The plaintiff testified to having sexual relations with D1 during this period. However, D1 admitted to the affair, but denied sexual relations with the plaintiff during the conception months, stating she was with D2. Plaintiff's argument. The plaintiff has applied for a DNA test to challenge the presumption of legitimacy under Section 112 of the Evidence Act 1950. The plaintiff argued that the Cortes Parens Patriae has the jurisdiction to order a DNA test to determine the paternity of the child. The issue was whether the court has the inherent jurisdiction or power pursuant to Section 3 of the Civil Law Act 1956 to order the child to undergo a DNA test. Decision. The High Court allowed the plaintiff's application for a mandatory DNA test. The court held that either the first defendant and either the second defendant shall bring child C to Hospital Tunku Aziza, formerly known as the Kuala Lumpur Women, and Children Hospital within 7 days from the service of the order on the first defendant and either the second defendant to enable the hospital to take all the necessary steps to obtain specimens. By intimate or non-intimate means as decided by a medical professional at the hospital from child C and the plaintiff in order for a DNA test be carried out to determine the child's paternity in relation to the plaintiff. Despite ordering the test, the court maintained that the second defendant, D2, remains the legal father of the child and refused to interfere with the child's status of legitimacy. Ratio decidendi, the court reasoned that the lack of specific statutory provisions regarding DNA testing under the Evidence Act 1950, creating a gap in local law. Referring to Section 3 of the Civil Law Act 1956, the court applied English common law principles and exercised its inherent jurisdiction as parens patriae to order a DNA test to determine the child's paternity. The court emphasized that ensuring justice based on the truth is fundamental. Therefore, the High Court, under its inherent jurisdiction, could order scientific evidence, such as a DNA test, in the child's best interest. Stare decisis. In Casvi, MPPL, and Anor, the High Court adhered to the doctrine of stare decisis in interpreting Section 3 of the Civil Law Act 1956, applying English common law to address a lacuna in local law, as established in Stone World, SDN, BHDV, and GARA, SDN BHD 2020 2MLJ 208. Which affirmed the judiciary's inherent power to intervene in the absence of specific statutory provisions to prevent injustice. The High Court also followed the judicial precedent in the English case of Re L.N. Infant, 1967, 3 WLR 1645, where the Court of Appeal held that the High Court has the inherent jurisdiction as parens patriae to order a blood test of a child. It was held that any judge of the High Court can order a test to be taken of a child's blood, where it is in the best interest of the child to determine his paternity. The court concluded that despite the silence of local statutes on DNA testing, it possessed inherent jurisdiction as parens patriae guardian of the child under English common law. By applying stare decisis, the court adhered to prior judicial reasoning where the court has inherent jurisdiction as parens patriae to order a DNA test of a child to uphold the child's right to know their biological identity. Therefore, by applying the English common law via Section 3.1 of the Civil Law Act 1956, the court filled the legislative gap in the absence of a specific Malaysian law to order a DNA test on a child. Overall judgment, the High Court granted the plaintiff's application for a mandatory DNA test, recognizing its inherent jurisdiction under the principle of parens patriae to order the test in the child's best interests. Despite the absence of specific Malaysian law on DNA testing, the court distinguished between legitimacy and paternity, ruling that the presumption of legitimacy should not prevent the discovery of biological truth. The court affirmed the child's right to know their biological identity. As a result, the court ordered the defendants to undergo DNA testing with the child. Additionally, if paternity is confirmed, the plaintiff's reintegration into the child's life must occur gradually, supervised by a child psychologist to ensure the child's welfare.